I am delighted to recommend this book to you all for a better and more complete understanding of modern arbitration law. My plea to all those who administer and all those who participate in international commercial arbitration is that they must strive towards an arbitral regime that kindles the spirit of arbitration. This kindling the spirit of arbitration is best encapsulated in that very evocative phrase, l'esprit arbitrage. Before my association with the ICC Court of International Arbitration, long years ago, I was ignorant of what that phrase really connoted. So I turned to my esteemed friend Michel Gaudet, who was then honorary president of the ICC Court of International Arbitration, for enlightenment. Gaudet was the living embodiment of all that was good and wise in arbitration. This is what he wrote back to me, and I quote, "The aim of arbitration is not to draw from the applicable law a decision against the parties involved, but only to clarify, together with the parties, what should be done in a given situation to achieve justice. Achieving this process requires all along that all participants be inspired by l'esprit l'arbitrage." Unquote. Simply and effectively put. My regret today is that there is just far too much legalese in international commercial arbitration and far too much disputation about law. The acronym ICA, International Commercial Arbitration, has become almost indistinguishable from litigation, which it was at one time intended to supplant. And moreover, the legal baggage with which international commercial arbitration is now weighed down continues to increase over the years. Just imagine, the ICA yearbook of 1976 made its first appearance with a slim volume of just 250 pages. In the last 4 years, it has expanded to far more than 1,000 pages per volume. Similarly, the 1999 edition of Fouchard, Gaillard and Goldman on international commercial arbitration is very informative, but also very bulky. 1,280 printed pages bound in hardcovers, richly annotated with ratios of hundreds of court decisions around the world, and splattered with extracts from and references to scores of international arbitral awards, all of which is, of course, most rewarding for lawyer arbitrators. But I have often wondered whether it is the function of private arbitral awards to develop international arbitral jurisprudence. I am of the view that the private nature of arbitration is wholly inconsistent with any law-making function. All that should matter at the end of the day in an arbitration is that the arbitral tribunal in a given case has rendered a result that commends itself to one and all as fair and just. ICA, the acronym for International Commercial Arbitration, I'm afraid has lost that lightness of touch that had characterized its early manifestations. Reasoned decisions, majority concurring and sometimes dissenting, are now increasingly long and turgid and much too full of legal learning. If private awards were intended for the parties alone, as indeed they are, they must be brief, the conclusions and main reasons being presented in a simple format. But unfortunately, some of us players in international arbitration have been muddying the waters, and I don't exclude myself from this criticism. We are all increasingly tempted to address a much wider audience, expecting to create something that will form part of a body of legal opinion which drives us to a more elaborate composition. Far too often these days, an award will quote or cite from other awards, rendered in what is stated to be a similar fact situation. This ignores the wise caution offered by England's Lord Chancellor way back in the year 1901 in the famous case of Quinn versus Latham, a leading case familiar to us all, that every decision must be read as applicable to the facts proved and not as an exposition of the whole law on the subject. Every case in which expressions of law are to be found must be read as qualified and conditioned by its own peculiar facts. I remember that Cedric Barclay, of early 20th century fame, was a doyen amongst English commercial arbitrators, and he was particularly renowned as a maritime arbitrator. I had the privilege of knowing him personally and on occasions working with him. In his lifetime, he had made some trenchant comments on the disquieting features of modern international arbitration. Way back in 1981, he had written, and I quote, "Arbitrators do not have to imitate the courts. Commercial justice can be dispensed with without the turn of phrase and the logic which is expected from the Court of Appeal. The AAA and the Commonwealth associations have survived without giving too many reasons. The short and concise decisions which we have given hitherto were much superior to the essays in jurisprudence which the ICC court and others now deem appropriate. Our function," and you were speaking of arbitrators, our function is to decide, not to teach. It is a fallacy that the publication of awards will teach others something. More often it leads to confusion and equivocation. Look at that bundle of 1,500 reasoned award, he says. How many have we learned from it? Unquote. And he then said, it is not the motivation that which one abhors, but the endless expositions and the padding with which we find infiltrating our system. Brevity is the essence of wit. Justice needs no adornment. Unquote. But in this new century, the 21st century, Cedric Barclay's distilled wisdom has fallen on deaf ears. What we find in this new millennium is a tidal wave of arbitral law, which has become too precedent-bound, even though arbitral awards are not judgments of courts. The spirit, the ethos, has gone out of international commercial arbitration. It has been transformed into what the late Sir Michael Carr, arbitrator emeritus and founder of the London Court of International Arbitration, once characterized as international disputology. My old friend Michael Mustill, formerly judge in the House of Lords, and later another worthy arbitrator emeritus, had spoken in the same vein. But Mustill said it in his own inimitable style. I quote, "Nobody has yet discovered why the dinosaurs became extinct, but it is a reasonable surmise that their bulk was a significant factor. And it would be a pity if arbitration went the same way. And he then added tongue-in-cheek, this is unlikely to happen, but it is at least worth asking whether a course of slimming might be in order. Nicely put. The danger is that international commercial arbitration, as a forum of dispute resolution, has become so overburdened by its own weight and size that it is being supplanted by other speedier, more fruitful, more rewarding methods. The alacrity with which over 50-odd sovereign states around the world signed on to the most recent Convention on Mediated Settlements, the famous Singapore Convention of 2020, is a pointer that perhaps all may not be too well with international commercial arbitration. I end with one last observation. International commercial arbitration is by no means the exclusive preserve of lawyers. Always remember that. In fact, the world of commercial arbitration is not premised on its participants possessing any legal qualifications. Remember, it is only in 4 or 5 out of the more than 170 New York Convention countries that there is an express legal requirement that the arbitrator must be a qualified lawyer. The New York Convention 1958, the Washington Convention 1965, the UNCITRAL Model Law of 1985, all of them are silent on arbitrators' qualifications. The only requirement is that the person appointed as arbitrator should be independent and impartial. And of course, he or she must have some brains. And I assure you that my friend Tariq Khan has brains in ample measure.